And so those are the introductions. Those are some introductory remarks. I wanted to get right into our first panel. With the first panel, we have three law professors, and in many ways they have led parallel lives, and led all three of them clerked at the Court of Appeals for the Federal Circuit. All three of them had a substantial amount of patent law practice, and now all three of them have been teaching patent law for a number of years, starting at the far side on your right, we have Professor Lisa Dolak. Lisa Dolak is the Angela Cooney Professor of Law at Syracuse University. She also earned her JD at Syracuse University, where she was first in her class. And not just right here, first in your class means something because first out of 150. Right there, it's first out of 240, which is even which is even more impressive. She also has a background in chemistry law and practiced patent law in upstate New York with a focus in that area. She clerked for former Chief Judge Paul Michel and has written extensively on ethics and ethical conduct issues, and the role of the courts in managing those, and also in managing the patent office. And she'll be our first speaker. I'm going to go ahead and introduce all three of you. Next to Lisa is Professor Lee Petherbridge, Professor Petherbridge comes from Los Angeles. At least that's where he's teaching at Loyola University in Los Angeles. He is one of the leaders one of the new leaders in the area of academia of really using sophisticated empirical tools to think about the intellectual property system. I love reading Professor Petherbridge's papers because they're both clear but extremely well done with their background. And of late, he's really been focusing on looking at the Federal Circuit and decisions of the Federal Circuit, and thinking about how their jurisprudence can be discussed in kind of a quantitative way that helps us think about where they're headed in the future, and how they might be categorically different from how other courts are operating. Professor Petherbridge also practiced law at Finnegan and Henderson, I think in D.C., and clerked for Judge Clevenger, who's now senior judge on the Court of Appeals for the Federal Circuit. And now closest to me is Professor Elizabeth Winston. Professor Winston is a professor at the Columbus Law School, Catholic University in Washington, D.C. In 2 of the last 3 years, Professor Winston was chosen by her students as the best professor of the 1L curriculum for teaching contracts class. She also teaches intellectual property classes such as trademarks and patent law, and like Professor Dolak, Professor Winston clerked for Chief Judge Michel on the Federal Circuit. She also practiced at the highbrow firm of Covington and Burling in Washington, D.C. Recently, she's written some interesting articles. One on false marking cases, which has gotten a lot of press. Her article was really kind of the lead article, and we were talking whether or not the courts cite her. They are using her article in making their decisions, and I really like her work because it not only does it advance the theoretical law, but it adds something that is very practical for how patent law should be dealt with, both from a policy perspective and from practicing patent laws. I think that our approach for this panel is that we're going to have the 3 speakers each talk for 15 or 20 minutes, and then we're going to have questions. Of course, at some point, if you have a burning question, you can jump up and ask it. And that's going to be just fine. But we will also have plenty of time after their initial presentations for more questions as well. And you guys can feel free to modify that on the fly if you like. So let's start with Professor Dolak.
otherwise. Sounds like I can hear myself anyway. And I don't know that I have much to say that the rest of you will find worth hearing. So let's see. I got to turn on. Is that right? I am absolutely delighted to be here. Although I had hoped, coming from Syracuse, to have a break from the snow for a couple of days. And I did. When the plane landed, there was no snow. And then I got an email from Robin that said, you know, Columbia has been hit by this sudden snowstorm, unexpected snowstorm. And my reaction was, well, you know, what's a little snow? I mean, come on. And then I got out there on the highway in the rental car, and the conditions just kept getting significantly worse. And so it was a challenge. And I think what was most jarring was all the cars, you know, up on either side of the road. The highway was strewn, littered with cars. So I was a little bit of a white knuckle drive, even from a long time upstate New Yorker. But it is a great honor to be here. And it's not only just a great privilege to be on a panel with such distinguished speakers who I count among my friends, and that's also a great honor. But this looks like a beautiful place. I've only been here for about a half hour, beautiful school. And I have to say that it has been an absolute privilege dealing with the members of the law review and the staff here. Everyone has been wonderful. I would like to talk today about judicial reform of the patent system. As you can see, my title, you know, this paper, which is still in progress, reforming the patent system case by case, Federal Circuit activism, or perhaps overreaction. So I'm just going to raise some questions in that regard. Let's see. Just advancing the slides now. Thank you. Okay, so obviously just a little bit of history that I think everyone here is probably well familiar with. We had in the 2003-2004 timeframe comprehensive reports urging comprehensive reform of the patent system. We had, going back even before 2003, back as far as ACES 2001, a series of congressional hearings and proposals, again, relating to wide-ranging reform, calculation of damages, injunctions, post-grant proceedings of various species, priority, in other words, first to file versus first to invent, reform of patent venue, inequitable conduct, eligible subject matter, best mode, and this doesn't even get all of the issues. So I'm just trying to make a point that it's certainly almost across the entire spectrum of the patent law. We've had proposals since then. Every Congress, at least the last 4 Congresses, including the current Congress. Now, many of these issues, as we've gone forward, as you know, have been addressed by the courts. At the Supreme Court, we continue to see a high level of activity regarding patent cases, including on issues relating to the availability of injunctive relief, subject matter eligibility, and obviousness, which was, of course, one of the issues that was featured prominently in those reports. Similarly, at the Federal Circuit, a very high level of activity in terms of judicial policy making. In the area, of course, of subject matter eligibility. After all, that's where Bill Speed began as an en banc case. We've had 2 en banc cases within this period of time relating to willfulness. And we've had a series of cases related to reform of patent damages. And again, this is just by way of example. There has been more substantive policy making going on in both courts during this rather tight period of time. I think you have to acknowledge it's been a lot of activity for a short period of time. I think it's fair to look at the Federal Circuit, and I think this is more than fair. It's an understatement to say that the Federal Circuit has been in a mode, has been responding to a lot of external influences. And we've seen this responsiveness take the form of comments, in speeches, and in opinions by individual members of the court. We've seen the court actually reach out and encourage the bar to file en banc requests. We've seen what I'm referring to here as campaigns on the part of the court as a whole, or at least as part of certain members of the court acting in panels as well as campaigns, I think it's fair to say, by individual judges on particular issues, calling for reform on particular issues. For example, willfulness. As I said, we've had two. We had the Norm Remsa case and we had In Re Seagate within a very short period of time, 2004 and 2007, respectively, on willfulness. With regard to venue, we've had a series of Federal Circuit decisions that have pulled in the direction of tightening the available venue for patent cases. And we've had recently, in the 2007 to the present time frame or so, a series of Federal Circuit decisions, the most recent of which is the Unilock case from early January, that again have pulled in the directions advocated by those who have called for reform, being more restrictive with respect to both venue, with all of these willfulness, damages, and venue. So I'm doing that activity. And of course, we've seen a dramatic increase on the part of the Federal Circuit in its use of the en banc vehicle, both in terms of hearings and in terms of rehearings. And again, some of the issues that the court has, this is not by any means an exhaustive list of the areas that the court has considered en banc. Willfulness, again, subject matter eligibility, and inequitable conduct in the currently pending Theracense case. And notably, not only has the court taken more cases en banc, it has taken a number of these cases en banc on its own motion. So I think, again, you've seen the Federal Circuit responding to external influences. Now, in general, at least what I read and see in the press and in the legal scholarship, the court has received, the courts have received generally good reviews for this high level of activity. And focusing on, for example, these are some of the kinds of comments you'll see in the press and in the legal scholarship. That the courts have, by their high level of activity, obviated the need for much of the previously called for and proposed legislative reform. And there are even people saying that in light of what the courts have done, at least some of what is at issue in the current pending Senate reform bill is just not needed. The courts have fixed the system in large respect. We've also seen commentators saying that at last there has been, as a result of the back and forth between the Supreme Court and the Federal Circuit, much needed crosstalk between the courts in the ways that the regional circuits talk to one another on issues, and the Federal Circuit has had no one to talk to. And now at last it has the Supreme Court to talk to, and that give and take has been advantageous and beneficial to the system as a whole. There have been many critiques in the scholarship in recent years, including by at least one member of this afternoon's program, critiques of the so-called undesirable formalism in patent jurisprudence, that the court tends to decide decisions. First of all, it identifies the issue, the particular issue, whether it's written description or subject matter eligibility or utility or whatever it is, and then gets inside that box and decides the cases along on that track. It doesn't take into account the kinds of externalities and the way patents are viewed in the marketplace as opposed to the way they're perhaps viewed in these narrow systems, so that there has been an erosion. And these decisions by the courts, both courts, reflect an erosion of that undesirable formalism. So again, the reviews have been generally good. I ask in my paper, is all this judicial reform necessarily a good thing? Does it matter why the Federal Circuit has been active of late in terms of evaluating whether it's a good thing? Do we need to look at the reason, what's been motivating the Federal Circuit? Does, for example, that high level of activity reflect a reaction on the part of the court or its individual members to public pressure, to political pressure in the broadest possible sense? It's not just in terms of seeing what's going on in the Congress, but reacting to some of the very harsh critiques that the court has been subject to. And just sort of lobbying, formal lobbying, informal lobbying as a general matter. If it does reflect that kind of a reaction, is it appropriate? Is that perhaps a good thing? We have a very responsive court. Is it helpful? Does the system benefit in the end? In other words, to what extent should patent-related judicial decision-making, including the court's deciding to decide. In other words, reaching out, asking for cases to be brought to it, just taking cases on bond solicitation, for example, deciding which cases to take on bond, deciding which cases to take in the case of the Supreme Court on certiorari. To what extent should that kind of decision-making be attuned to external influences as opposed to sort of, calling balls and strikes, in this case is landowner. I explore whether, I take the example of TheraSense, primarily because, as Dennis mentioned, it's an area that I know, one of the few areas I know, so I'm going to stick with what I know. And I look at TheraSense and I consider whether it, what it tells us about the answers to some of these questions. And of course, this is a case that you'll recall, it's a complex case, at least in trying to boil it down on some slides. So I skipped a lot of steps on the slides. But as you can see, you'll recall this was an AVID patent that was held unenforceable for what was described as a failure to disclose statements made to the European Patent Office during revocation of a counterpart of a prior art patent. So this prior art 382 patent is prior art both against the patent, was prior art as it was coming up, the patent had issued through the Patent Office. It was also prior art used in this revocation proceeding. So it's prior art in both contexts. And an issue in the case was what, boiled down, what did the 382 patent teach? Again, a lot of text on this slide, but again, it's the bare minimum in terms of understanding the case. In the EPO, the specification of the 382 patent, the specification of the 382 patent, wherever it's found, says, optionally but preferably, when being used on live blood, a protective membrane surrounds both the enzyme and the mediator layers, permeable to cool to water and glucose molecules. So that's a quote from the specification of the prior art patent. Optionally, but preferably, there is a membrane. In the EPO, the attorney argued, quoted this language and immediately below it, no space between the two items of text. It is submitted that this disclosure is unequivocally clear. The protective membrane is optional, but preferred when used on live blood. In the USPTO, in contrast, after a protracted prosecution where the 382 patent came up time and time again, the examiner, in response to the applicant's offer to make a showing, or its characterizations of the 382 patent, the examiner said, fine, put in a declaration. And the declaration was submitted by an R&D director who said, one skilled in the art would have felt that the 382 device would require a protective membrane if it were to be used with live blood. Therefore, a person of ordinary skill in the art would not read the 382 as teaching the use of a protective membrane, as teaching that the use of a protective membrane is optionally or really preferred. And the attorney, in submitting that declaration to the Patent Office, said there is no teaching of unprotected electrodes for use with whole blood in the 382 patent. So those are the statements that the two judges on the Federal Circuit, that the trial court and two judges on the Federal Circuit found to be directly inconsistent. Procedurally, you'll recall last January, the panel affirmed the trial court's determination of unenforceability. There was a vigorous dissent by Judge Lynch, and on April 26, 2010, en banc rehearing was argued, and the oral argument was heard on November 10th, and we're waiting for the decision. The en banc order, when it came out, indicated the Federal Circuit's willingness to consider inequitable conduct across virtually the entire. It's hard to identify an issue with inequitable conduct that isn't subsumed in this en banc order, right? And again, just a paraphrase. What about the framework? We're going to revise the framework. How? What standard? Materiality, intent should be abandoned the balancing. What can we learn about materiality and intent from other kinds of contexts? So, far-ranging en banc order. So, I look at whether TheraSense its appropriateness as a vehicle for reforming inequitable conduct. I have to acknowledge that I signed, not a merits brief in this case, but I signed the professor's brief urging the court to take the case. I will say that I signed that brief because I felt, based on the political climate, that the court would take the case. I thought it was a foregone conclusion that the court would take the case, and I thought I might weigh in on the merits, depending on the issues that were involved. I also will note that the brief I signed didn't relate in any way to the facts of the case. It was kind of a policy brief on a general reform of the doctrine, because I didn't think these facts were terribly compelling, I have to say. But in any event, so you look at the TheraSense as a vehicle for reform, and just some of the things that I'm talking about in the paper. You could look at this, the courts looked at it as a withholding of information from the EPO prosecution. You could also look at it as a misrepresentation of facts, a misrepresentation of what the reference showed, at least in light of what the applicant had previously told about the patent office. The issue of whether it's mere attorney argument versus misrepresentation of facts comes up in the case. I think it's important to note that the examiner conditioned the allowance of the patent in the patent office on the submission of a declaration and didn't just view it as decided on attorney argument. We can look at the decision reviewed. The trial court held the the information was highly material. It made 5 separate findings supporting deceptive intent. This is not a case where intent was inferred from materiality. And it made credibility evaluations of both the declarant and the attorney involved. And so I think that's important in terms of the deference that's owed to the trial court. Some other issues that I think are relevant to consideration of this topic are the fact that this was a protracted prosecution. And the trial court in its decision also pointed out that and the panel majority here, that the declarant was not a person of ordinary skill in the art. And in fact, the inventor, one of the inventors on the patent, actually testified that he disagreed about the state of the prior art with the declaration. So those are some of the factors to look at. Other things I think we have to look at is Judge Lynn, who I think it's obvious if you look at the decisions of his dissents and concurrences in an equitable conduct case, like this is an issue that matters to him and that he thought reform was needed. The majority takes him to task with his reading of the facts, and I think that that's a fair critique of Judge Lynn's reading of the facts, and I think we have to ask whether, had Judge Lynn not written the dissent that he wrote, whether the case would have been taken en banc. I think another issue is whether the facts in the case actually raise all of those issues, and whether they fairly raise any of the issues on the en banc order, but certainly whether they raise all of those issues in the en banc order. And maybe that's okay. I mean, the Federal Circuit in its en banc decisions over the course of the decade has issued in a number of cases en banc orders that reach to questions that aren't arguably raised by the facts of the case before it. Again, it's a form of judicial activism, and I'm not using that term pejoratively. I'm just raising the question of whether or not that's the way we get to the right outcome. The amicus briefs, if you look at the amicus briefs, the merits briefs in TheraSense, they show a wide disparity of viewpoints across the entire spectrum of issues. I mean, I saw one chart prepared by a person who had analyzed all the amicus positions, and I mean, talk about all over the map. So it causes you to ask the question of whether it's just too much to deal with one case. The oral argument was heavily focused on just one of those issues, on materiality, which may not be the hardest issue in the case, right? Materiality might have been the easiest issue in the case, I think it's fair to say. And yet, so in terms of the value of the oral argument in terms of the judge's decision making, I think we have to ask about that. And there have been some post-argument critiques about this. Notably, there were a number of other requests for en banc rehearing in inequitable conduct cases, and other requests for hearing by the Supreme Court on certiorari over the years. And I look at some of those cases and consider whether or not they might have been better vehicles for maybe taking up one issue at a time. Some other considerations that I'm looking at are the assessment of the court's success in other recent en banc efforts on things like willfulness. More notably, we had to have 2 en banc decisions in the space of 3 years. And some of the other issues. And I guess it's way too early, and that's an overstatement, that I'm assessing the success. It's way too early to know the success of these cases. But whatever we can learn about other en banc efforts. Looking at the political science literature on courts as political actors, in other words, as policymakers or reactive policymakers, as well as legislation as an alternative. So however it comes out, I mean, it may turn out that the court, having taken their sense, may turn out to be a great thing for the patent system. And, in a number of ways. We just don't know. We don't even have the decision yet. But I think it raises the question of the court as reactive. There, as I said, were a number of harsh critiques of the Federal Circuit. I think, again, there's a high level of evidence, at least, that the court has been responding in terms of the suddenness of this high level of activity. A lot of these issues, right, that have been taken up by the courts have been long simmering. I mean, obviously, the Microsoft versus I4I case, right, the clear and convincing evidence standard is not new. A lot of these issues, the courts have had these positions for a long period of time, and all of a sudden, they all get taken up in a very short space of time. And so I think that's notable. Again, some commentators have said that's a great thing, let the issues percolate in the lower courts for a long time before the Supreme Court steps in or the en banc Federal Circuit steps in. But I guess my point is that even if there was so much wrong with the patent system that we need to fix all of these things to such a great extent, is it too much at once? The scientist in me cries out for controlling variables, right? And so I just think I think it'll be a very interesting, perhaps next 10, 20, or 30 years in terms of what have we done to our patent system. And that's all I have. Thank you very much.
Good morning.
Good morning.
All right, so wonderful to be here today. First of all, like Lisa, made it through the snow. I was very happy to do it. Enthusiastic to be on a panel with Lisa and Elizabeth Winston. And it's great to be involved with a program involving Dennis. Dennis, as many of you know, does wonderful scholarship, but he's also done tremendous service to the patent system and to legal scholarship by maintaining the patent Clio blog, and we're all grateful for that. And of course, I'd like to thank as well the students of the Missouri Law Review for the good judgment of putting on a conference like this and really sort of carrying it off so well. It's been a real pleasure to be here so far, and I hope that what I have to say is of interest. All right, so what we're going to talk about is the Federal Circuit and legal scholarship, right? So the talk is going to cover a couple of things. There'll be an introduction where I'll talk a little bit about what we're talking about with respect to national circuit courts and Federal Circuit. I can probably keep that at a minimum for this audience. We'll get into some discussion of why we think, Dave and I think, that studying the Federal Circuit is interesting, and then we'll get into some more specific discussion of the theoretical and empirical context that gave rise to the research questions we're going to talk about today. We'll talk about the research goals, of course, the study design, and then we'll get into some results that I think are important for a couple of reasons. One is they shine some light on a sort of a current empirical dispute about how the Federal Circuit goes about judicial administration, and they also set the table, of course, for some additional hypothesizing and some future directions about what we can do to study the Federal Circuit more in the future. All right, so introduction, what's a National Circuit Court? Many people in this audience probably have a good sense of what we're talking about here. But of course, our sort of basic regional circuit system involves a set of numbered circuits, right? And those numbered circuits are bounded by geography, and that has some implications for the appeals that they hear, right? Typically, these circuits hear appeals from district courts or lower tribunals that decide matters within their geographic regions, right? And so regional circuits are bounded not only by subject matter, right, in the sense that they're bounded by federal questions, kinds of subject matter things that federal courts can hear, but they're also bounded by geography.
Right? National circuit courts are different. Right? They're also found in national federal courts, at least the national federal circuit court is of course bounded by federal law and things the federal courts can hear, but it's also bounded by subject matter, in particular subject matter that's what are the cases about, right? Not where they come from, but what are they about in terms of the subject matter. And Dave and I think the prototypical national circuit court is the federal circuit, of course, right? As most people I think would probably agree. Right? And just so we're clear, the way this works is the federal circuit hears appeals sort of no matter where they arise, right? So appeals can arise, back where I'm from in Los Angeles, and if it's a patent case, for example, the appeal would typically go to the United States Court of Appeals in the federal circuit in D.C., or if a patent case or some other kinds of cases, in particular patent cases occur in, say, a district court in New York, the appeal is going to go to the federal circuit, right? So the federal circuit hears appeals from district courts and lower tribunals, not based on sort of where they arise particularly, but based on what they're about, right? What the subject matter of the appeal happens to be about, right? So that's what the federal circuit is sort of up to, and that's what we're talking about when we're talking about a national circuit court, right? Now it turns out a sampling of the subject matter that gets appealed to the federal circuit shows sort of a veritable, smorgasbord of things that the federal circuit gets, right? So appeals from Vaccine Compensation Act claims, appeals from the Court of International Trade, appeals from the Merit Systems Protection Board, right? Things, maybe lots of people in this room have heard of, maybe not, right? Agency contract boards of appeals, veterans benefit claims, patent office claims, right? If you get your patent application rejected, you can appeal that to the federal circuit. Of course, patent cases that come up from the district courts, tax refund cases, actions against the United States under Section 1346, right? Based on the Constitution, statute, regulation of contract, Indian claims, takings claims, trademark registrations, right? A whole bunch of things get appealed to the federal circuit. Right? So why study the federal circuit? I guess maybe I could stop right after showing you that slide, right? Because once I show you vaccine compensation claims and things like that, everyone is ready to dive in. But there are other reasons, right? So there are other reasons as well, right? Not to mention, I'm only half joking, right? The federal circuit's jurisdiction is actually very, very interesting and very, very sort of stimulating to be a part of. Certainly, it was for me when I worked there. So why study the federal circuit, right? So there's lots of interest in emulating the federal circuit, right? And this may or may not come as a surprise to some of you, both in the United States and in other countries, right? And so areas like bankruptcy, tax, Social Security. A few years ago, Congress was playing with the idea of giving the federal circuit jurisdiction over immigration cases. And in other countries, courts, or other countries have actually considered developing a court like the federal circuit to hear intellectual property matters or patent matters and things like that. So there's lots of interest in the federal circuit and the model of judicial administration that it provides. Right? Why else study it? Well, it's innovation in judicial administration, right? And I don't know if I can say this here in Missouri. I almost, every time I sort of look at the slide, I want to write the little word "damn it" like down underneath, right? Like, why would you not be interested in studying this? What could be more interesting than sort of experiments in judicial innovation, right? Or innovation in judicial administration, right? So those are some very general and broad reasons that it's fun and interesting to study this federal circuit. And there's more specific things you can get into, of course, right? And how those things play out on the ground. And that brings us a little bit closer to the specific issue for today, right? So today the topic is the federal circuit and legal scholarship. It turns out, right, maybe surprising, maybe not for some of us, that the federal circuit's relationship to legal scholarship has generated a significant amount of ink, and it's been sort of primarily used as the basis to launch a criticism of the federal circuit, particularly widely accepted criticism, right? And as I'm about to explain, this criticism is particularly relevant to today's symposium because it essentially boils down to the criticism that because of how the federal circuit's jurisdiction is structured, the court does not, nor should it be expected to do a good job of developing the areas of law to which it's been assigned. Right? And so these quotes I'm about to show you sort of reflect the empirical basis for this criticism. Right? So you see things in the literature like, empirical research has shown that the federal circuit is less likely than other courts to cite legal scholarship in its opinions, or specialized institutions have insular tendencies. For example, the federal circuit appears to rely less on scholarship than the regional generalist courts of appeal. Right? This last quote in particular comes from the National Academy of Sciences report that's probably stimulated some of the patent reform efforts that have taken place over the last 5 years or so. All right? And this kind of conventional empirical wisdom gives rise to labels and categories that get laid on top of the federal circuits and the federal circuit and its judges. And so you get labels like the court and its judges are insular. The court and its judges are disconnected. The court and its judges are lacking in intellectual curiosity. Right? So these are things that people have written about the federal circuit. Lots of people have written about the federal circuit and repeated about the Federal Circuit, right? And so I just want to sort of summarize some of the, I don't know, what we might call the logical inferences that come from this, right? So we've got this empirical evidence, right, that we have here, and this evidence is the Federal Circuit uses legal scholarship less often than the regional circuit courts of appeals. And one of the inferences that's sort of commonly taken from that is that the Federal Circuit is therefore more intellectually disconnected than the regional circuits from important sources of information that should inform jurisprudence, right? And then the second inference is lacking important information, the Federal Circuit cannot do as effective a job as the regional circuits in developing jurisprudence, right? So this is, and again, I want to sort of emphasize a couple of things here. First is how much weight the sort of lack of use of legal scholarship evidence carries. This is actually something that's very commonly repeated. It's in sort of the legal academy. It's almost received wisdom that the Federal Circuit doesn't cite legal scholarship, and that that's important to these particular inferences. The second thing I want to emphasize is that it should be obvious that evidence, any evidence, right, for how well the Federal Circuit develops its jurisprudence is going to include more things than just whether it cites what law professors have to say at symposia like these, or in the writings that they publish in law reviews, right? So there's lots and lots of variables that could go into this, right? So of course, when I say that this piece of empirical evidence has been important to these inferences, these arguments and claims that people made, it is very important, it carries a lot of weight, but of course people that have criticized the Federal Circuit's jurisprudence have criticized it for other reasons as well, right? So let's be clear that this is sort of disposing of everything, right? So that's sort of brings me to the last thing I want to emphasize before jumping off a little bit, which is that the empirical contribution of this project is to really address this perceived empirical wisdom, right? Sort of this claim that the Federal Circuit uses legal scholarship less often than the regional circuits. Once we address that, right, we'll provide some information. I'll provide some information that shows that doesn't mean all of a sudden that I'm going to sort of land in the place that the Federal Circuit necessarily develops its jurisprudence well, and we can sort of wipe out these inferences, right? Because there are other pieces of information that support those kinds of things. Right, so focusing on this claim, that empirical research has shown that the Federal Circuit is less likely than other courts to cite legal scholarship in opinions. Right? So the first question, of course, is where does this come from? Right? This claim comes actually from an excellent and seminal paper authored by a noted patent law scholar, a colleague of all of ours in the Academy, a person named Craig Nard. The name of the paper is Toward a Cautious Approach to Obeisance, and it's the role of scholarship in Federal Circuit patent law jurisprudence. It was published in 2000. In the Houston Law Review, right? So in this study, Craig compared the use of scholarship in Federal Circuit reported patent opinions with the use of scholarship in Second and Ninth Circuit copyright and trademark opinions, and there he found what you see. This is a quote from the article, right? The empirical data reveal that the Second and Ninth Circuits cite scholarship roughly 4 times as often as the Federal Circuit, right? So Dave and I have gone over the study. And we have reason to think that there are no mistakes, right, in the observations that Craig made. We have no criticism of that. In fact, we have really no criticism of the study. The big things that we took away from looking at the study was there's only one study. Right? There's only one study that provides the basis for this sort of broadly repeated and highly influential empirical claim. And then if you look at the study, it's almost immediately apparent that the data set used doesn't easily lead to a claim that's this broad. And this is something about which Craig is actually pretty clear in the paper. It just seems to be one of those things that everyone's kind of ignoring, kind of the sort of the parameters of the data set that he used, and the things that he actually said in his article that limit the scope of the claims that can be made from it. All right, so that's sort of the kind of existing empirical landscape. Right, so our research goals were to do a couple of things. We wanted to examine the claim that the Federal Circuit uses legal scholarship less than the regional circuit courts of appeals. And we wanted to consider the implications of those results, what they suggest about the Federal Circuit's relationship to legal scholarship, and what issues they might raise for the future investigation. Right, so here goes the study design. Right, so the study design is pretty straightforward. Dennis was awfully generous talking about some of the empirical work that I've done in other places. This is going to be maybe, I don't know, not sophisticated, right? So this is going to be pretty simple, pretty straightforward empirical work and pretty straightforward statistics, along with a bunch of remarkable assumptions, right? So here we go, right? So the first one to point out is legal scholarship here means law review articles, right? And that's the way this claim comes up. I haven't sort of specified it up to this point, but we're talking about law review articles, things that people like myself and Dennis and Lisa and Elizabeth and the other luminaries are going to hear from this afternoon. Right. So we're talking about legal scholarship in the terms of law review articles. So we're not talking about Professor Chisholm's patent treatise, or nobody writes complaints that said the Federal Circuit doesn't cite to Moore's federal practice often enough, right? It's more that we just law professors that write law review articles are the people that are getting ignored, right? So that's the first thing, right? Legal scholarship means law reviews. Right? The second thing to take into account is that when we're talking about the use of legal scholarship, we're talking about citation to legal scholarship in reported opinions of the Federal Circuit. Right? This, of course, is a remarkable assumption, right? In the sense that it's almost entirely not going to be, or it's not. It can't be exactly true, right? So judges might use legal scholarship and not even know it, right? So, for example, at the Federal Circuit, the librarian sends things around, right? Sort of, referencing new articles about the Federal Circuit or about the patent law. And I think some people do sometimes read some of those articles. It's like those of us who read articles, right? You read an article, an idea might start to germinate, you might start to think about stuff, but sometimes you don't sort of go back and connect it to the thing that you read, right? In addition, it turns out that the judges will also sometimes use legal scholarship, read an article, get an idea from it, know they got it from the article, then when they write the opinion up, they decide not to tell everybody that the idea kind of came to them from reading a piece of legal scholarship, right? So, and there's I don't think there's anything wrong with that, right? You're like sort of plagiarizing in your judicial opinions, right? So you can do that, right? And that's perfectly fine. But the point here is that scholarship's getting used more than we're going to be able to detect just by looking at how often people cite to it, right? So that's the important thing. Now, the benefit, of course, of looking at citation is it's kind of fairly easy to count, right? That makes doing a study like this easy. We don't have to sort of read an opinion and make some guess about, whether Stephen Chabelle has influenced somebody or something like that when they're not cited, or whether Mark has influenced somebody and they didn't cite to the article that Mark published, right? So that's why we go with these. All right. So the way we go about this is we just identify and collect all relevant opinions, right? And if you look at this, we collected all the reported opinions in Westlaw, right? And we did it actually this is part of a larger project. We actually went all the way back to 1950. But for what the data I'm going to show you today, we're just talking about 1990 to December 31st, 2008, right? So all the reported opinions from all the regional circuits and all the reported opinions from the Federal Circuit through that particular period of time, right? And so we then took those opinions after we collected them and then we coded them. And we coded using three different mechanisms, right? The first was essentially a search, right? Dave and I spent a lot of time developing a search that finds citation to law review articles only in judicial opinions off of Westlaw, and apply that. So we just ran it over and over and over again on Westlaw searches. And the search is actually, since we published that search, we published it last summer. Some librarians at the Cornell Law Library they have a blog and they sort of take a look at it, and they blessed it, I guess, in the sense that they said it's about as good as we can do in terms of that kind of a search. The other thing we've done is we developed a Perl script that allows us to read the opinions, right? So that's the first way of coding when we're doing the searches. Well, we can just find an opinion, right? If the opinion cites a piece of legal scholarship, we can count it as a 1. We have then developed this Perl script that actually reads the opinions a little more specifically, where you can actually find the specific sites and grab them out as well as count them, right? So we can now read the opinions and sort of take out judge-specific information, right? So we can know stuff about the caption, who wrote the opinion, whether it's a dissent or whatnot. And then we can say, well, look, there were 3 citations to law review articles in this particular opinion. All right, and so that's the other thing. And then the last form of coding we did, and you won't see much of it, so I'll be pretty brief, is some human coding. And when we did human coding, we used a technique called Cohen's kappa to assess intercoded reliability. All right, so once we had done all this collection of data, we engaged in statistical summarizing and analysis using essentially off-the-shelf statistical software, things like SPSS, Excel, and numbers, right? So that's what we did, and here are the results, right? So first, right, does the Federal Circuit use legal scholarship less than the regional circuit courts of appeals? Well, what we're seeing on this slide is a proportion, right? This is the proportion of reported opinions citing legal scholarship for all of the circuits over the last 19 years. And the way to read this is, well, here's the Third Circuit at the top. They're citing about 1 in 10 opinions, right? And then we come down to the bottom, and I guess there's a little bit of local charm to this. Right? So the Eighth Circuit is down at the bottom, 1 in 65 reported opinions, and they citing legal scholarship. And the Federal Circuit is in about like 1 in 28 and a quarter, right? So that's what we're talking about. So the takeaway here, to the extent there can be a takeaway from this slide, is that, well, look, the Federal Circuit they haven't sort of fallen off the bottom. That would be the Eighth Circuit. The Federal Circuit is sort of within a range defined by some of the other circuit courts of appeals. All right, so proportions are nice to look at, but when you summarize things that way, you do lose a lot of data. So what we did was we looked at our judge-specific data, and we tried to develop a cumulative distribution of the way in which judges cite legal scholarship across the circuits, right? And so what we have here are two lines. The white line is a cumulative distribution for the regional circuits, and the blue line is a cumulative distribution for the federal circuit, right? And the way to understand this distribution is, what we did is we took the judge that cited the least amount of scholarship and figured out what proportion of all the scholarship cited was theirs, right? Then we went to the judge number 2, added that person's contribution to judge number 1, went to judge number 3, added that person's contribution to the overall percentage to the next, to those two previous judges, and that's what we did all the way across this particular graph, right? And so this line you see out here, this regional circuit line that's in white, it's a very pretty line. It's actually an empirical line, and the reason it's an empirical line is because there are so many circuit court judges in that line, 342, right? So that's the regional circuit line, and then the federal circuit line is here in blue. Obviously, many fewer judges. I think there's something like 19 judges or something like that in that particular line, right? And so that's what you're looking at. What you can see when you look at this line is a couple of things that we think are interesting, right? We think if there's any important takeaway message here, it might be that these lines aren't straight, right? It's not like you add a judge and then you sort of just go up linearly. What you have is a tail left, right? And so you can see that there's the distribution here sort of indicates that a relatively small number of judges, and in fact it's written on the slide, a relatively small number of judges are actually responsible for like half of the citation, right? In the regional circuit, something like 13.74% of the judges can account for half of the citation. In the federal circuit, about 15 3/4 of the judges account for about half of the citation, right? So a relatively small number of judges are responsible for sort of the overwhelming amount of the citation. All right, so that suggests maybe looking at the data in a different way, right? This distribution that we're looking at, and so we started to look at average in a different way. We got out proportions and we went to medians, which is sort of a more robust statistic when you have a distribution that looks like that. And when you do that, you see the federal circuit and the Ninth Circuit actually share a median at 16, right? This is 16 citations per judge, right? And then if we've got some more courts that start to sort of pile in there underneath the federal circuit, right? Sort of suggesting that, if we look at kind of judge, specific activity, the federal circuit starts to look a little bit closer to the middle even than they did before, and even the Eighth Circuit, right? Sort of, it's a little bit of bang, right? So that's what happens when you look at the median. And so the question, of course, is what's going on here, right? And it's hard to make a lot of concrete conclusions about this, right? But there are a couple of things you might be able to say, right? Which is, well, maybe we'll jump to it and sort of show it on the next slide. But does the federal circuit use legal scholarship less than the regional circuit courts of appeals, right? And so the answer is probably something like, depends how you count, right? At a minimum, right, it doesn't appear to be the lowest user of legal scholarship. And when you consider it at the level of individual judges, its behavior seems to locate somewhere near the middle of all the circuit courts of appeal, right? So that's the federal circuit in terms of legal scholarship. What else seems to be going on here? Well, the federal circuit seems to be short, right? Maybe one or two what we call, or what I'm calling, Dave and I are in a dispute about what we're going to call these people, legal scholarship files, right? And so by legal scholarship files, what we mean are judges who really like to cite to legal scholarship, right? So in other words, what the federal circuit doesn't seem to have is they don't have Judge Posner sort of on the circuit, right? Or they don't have Judge Becker on the circuit, right? They just the highest cider I think of the federal circuit is actually Judge Plager. So Dave and I actually thought we could make a demonstration of this, right? So what I'm about to show you doesn't actually add any new data. It's just taking the data we have and sort of manipulating it a little bit to give you a sense of what we're trying to describe here. And what we did was we took the top two citers at the federal circuit, Judge Plager and Judge Newman, and we traded them with the top two citers at the Ninth Circuit, which happened to be Judge Reinhardt and Judge Kaczynski. Right? So when you do that, right, here's the before, right? On your left is the before, and the Ninth Circuit sort of running along at kind of an average citation per judge of about 30. Of course, they have exactly the same mean as the federal circuit. The federal circuit's down here with a relatively low mean. You flip these top two judges, and all of a sudden the federal circuit jumps up to essentially where the Ninth Circuit was with respect to average citation, and the Ninth Circuit sort of falls back to not as low as the federal circuit in absolute numbers, but in rank it falls back to about where the federal circuit was, right? So this is just to make the point, again, not any new data, and the Ninth Circuit, to be fair, was chosen somewhat arbitrarily, not entirely. It has the same median, that's one of the reasons we chose it, and it's also second only to the federal circuit in the administrative docket that it has. All right, so that's that. And then a couple of future directions in my last minute or two, right? So what's the significance of legal scholarship files? I'm just going to sketch like 4 really quick things here, and then I'm going to wrap it. We have thought about these things. We have some ideas. I'm certainly willing to talk about it during the questions. What's the significance of these legal scholarship files? what are the factors that affect the Federal Circuit's use of scholarship. Dave and I have done a different study where we looked at regional circuits, and we have some idea from there empirically of factors that affect courts' use of scholarship. Courts are busier, but there are a lot more law review articles. They're easier to find. Ideology actually turns out to be important, a predictor of citation. Should there be a federal circuit for copyright and trademark? Interesting question given what we find, right? So this is patent cases at the Federal Circuit. Federal Circuit citing patent cases about, like it's citing everything else, a little bit higher rate, but right in that territory. But Greg, of course, finds that they're about 4 times less than the Second and Ninth Circuit. And so what does that mean? We're not really sure what it means. It could mean something as mundane as, well, the Second Circuit and the Ninth Circuit don't get that many copyright cases. When they get one, they get really excited about it, and they spend a lot of time on it, right? It's like something to do. The Federal Circuit maybe doesn't feel that way about patent cases because they see so many of them, and so that might be the only sort of distinction here. It could mean something more significant. It could mean something like the regional circuits are having a tough time. Maybe they're farther behind the bar and kind of the bleeding edge of copyright and trademark law, and as a consequence, they need scholarship more than the Federal Circuit does when it gets to patent law. And if that's true, well, then maybe that suggests that there might be some interest or some rationale for having a Federal Circuit or a Federal Circuit or the Federal Circuit being involved in copyright and trademark cases, right? It's just a perhaps right here. It's just sort of an open idea. And then finally, does the Federal Circuit rely on legal scholarship as much as it should, right? A couple of broad points here. Everybody focuses on judicial behavior. Almost nobody focuses on academic behavior in the context of the Federal Circuit. There's actually a fairly robust literature on academic behavior when you get outside the Federal Circuit, and you find out that everybody's complaining about the circuit courts not citing legal scholarship as much as they should. Then, of course, bar behavior. We looked at some briefs. I don't have any data to show you. Acknowledgements, my collaborator, Dave, is looking down on us now. And then, of course, some research assistants that have done outstanding work for us on this project. Thank you.
I didn't manage to bring my very own pointer and hook up my lovely laptop. I'm incredibly impressed. You guys are also not going to get my experience in my first year class. I can tell you I would have already done 3 laps around the room. I am not known for staying still. Very delighted to be in Columbia. My best friend actually grew up in Columbia. She moved away from high school to Rochester, Minnesota. But she was very excited when she heard I was coming here. She's now second in command of research and development at NASA. So she's done just fine for herself. Columbia, I'm sure, had a great part in that great upbringing. I am delighted to be here with Dennis. I remember years ago I was having a casual lunch with Bill Routledge, who was then the president of ACLA. And he said the first thing he did every morning with his cup of coffee was run the computer and read Patent Me Up. And I said, that sounds exactly like what I do, but I have Coke. I take my coffee cold with bubbles. All right, so as I was looking at this, I looked at the court's structure, and I said, how does the court's structure impact the development of the law? And I said, I'm going to take a more literal approach to this. If we're asking how the Federal Circuit's structure impacts the development of the law, rather than how the courts impact the development of the law, we must be saying there's something different about the Federal Circuit. So I thought it might be fun to kind of explore some of what makes the Federal Circuit different. It's quirky, we all know that, not just in its opinion writing. There are many things that differentiate the Federal Circuit from other circuit courts. And today I'm going to just touch on a few of these, I'm going to call them quirks. I like that word a little better than peculiarities. All right? So clearly, first, we touched on it, obviously jurisdiction. Okay? The court is more than a patent court. 1988 national meeting. Judge Markey sitting in the back of the room. Judge is moderating the panel. And the panel moderator said that the Federal Circuit was a specialized patent court. Judge Markey, who's sitting up there, leaps to his feet and screams that it is not a specialized patent court. There is no such thing. That the Federal Circuit is a national court, as you like to refer to it. Okay? If you go to their website, they have all these beautiful statistics that they've done where they do an analysis. It says about 44% of the cases are intellectual property, 37% are administrative, and the remaining 18% focus on money suits against the United States. Again, the IP cases are predominantly patent law cases, but not all. There was a recent interesting copyright case. The Postal Service issued stamps, and on the stamps they put pictures of the Korean War Memorial. Copyrighted work. They were sued for copyright infringement by the owner of the copyright. And the Federal Circuit said, yeah, that's not fair use, you're making money off of it, you know, try again. And they were found guilty. They have jurisdiction over infringement suits brought against the United States for violation of rights referring to protected plant varieties, mask works, other things like that. They get appeals from the Trademark Trials Appeals Board. They had a lovely case recently, 1-800-MATTRESS was trying to register mattress.com, and the Federal Circuit, very surprisingly, found this to be generic. It didn't really add a whole lot, and his registration was denied. Moving on from the jurisdiction, we can look at the composition of the bench, which is quite unusual. All right? There are many different aspects about the bench that make it unusual. One of them is something that's referred to as the Baldwin Rule. And except in the District of Columbia, each circuit judge shall be a resident of the circuit for which appointed at the time of his appointment. While in active service, each circuit judge of the Federal Judicial Circuit will live within 50 miles of the District of Columbia. In each circuit, other than the Federal Judicial Circuit, this does not apply. And in fact, in the District of D.C., the Court of Appeals for the District of D.C., Judge Karen Henderson lives in South Carolina. She does not live, there's no restriction on where you have to live to be on the D.C. Court of Appeals. Okay? The Circuit Court, sorry. Informally, it's known as the Baldwin Rule. It's in reference to Federal Circuit Judge Philip Baldwin, who Judge Michelle was actually, that's who Judge Michelle took the seat of. And he was living in Texas while serving as a member of the court. His residency requirement is unique to the Federal Circuit. It's hotly debated, and in fact is in the manager's amendment in Senate Bill 23, which will be on the floor on Monday. And they are suggesting the repeal of it. And all they're doing is taking out the one line. They're taking out the second sentence, so it'll no longer say that while in active service, each circuit judge has to live within 50 miles. Whether it'll make a difference or not, I don't know. Appointees have relocated to Washington, D.C., and the results are that, you know, people have come from all over. Judge O'Malley came from Ohio. We have Judge Plager, who was dean of the Indiana School of Law. Judge Laurie resided in Philadelphia. We have judges that have come from a variety of places. No judge has ever turned down a nomination for residential purposes, and no candidate has proffered the Baldwin Rule as a reason to decline being vetted for position on the Federal Circuit. Judge Michelle has come out in favor of it, arguing that it promotes the collegiality, and that in a court with as technical and as difficult a docket as it has, it makes a lot of sense for judges to be able to go up and down the halls and talk to each other informally, and it forces more of an acquisition of knowledge in rapid fashion to have everybody living there. Other unusual things about the panel. Panel size. The Federal Circuit can sit in expanded panels. In each circuit, the court may authorize the hearing and determinations of cases and controversies by separate panels, each consisting of 3 judges. The United States Court of Appeals for the Federal Circuit, notwithstanding the first sentence of this subsection, may determine by rule the number of judges not less than 3 who constitute a panel. It's sat as an expanded panel format, most often as a 5-judge panel. And it's done this several times since its formation. Judge Clevenger said in 2002 that when the court was first formed, 5-judge panels were used from time to time. I don't know why they picked 5. The statute said it could be 7 or 9. So, being a law professor, I said, well, why did they pick 5? I mean, that's the kind of thing we get to do. It's fun. You get to dive into it. And so I was looking around, and I found this hysterical article from Judge Rich called something to the effect of 30 years of this judging business, what's it like? Okay? And Judge Rich said that practice, as far as he knew, dated from the in-bank 5-judge panels of the CCPA, Court of Customs and Patent Appeals. And both the CCPA and the Court of Claims, which were the predecessors to the Federal Circuit, they both sat as 5-judge panels. The CCPA was this nice little 5-judge court, this is Judge Rich's language, pretty much specializing in patent, which in recent years have managed to have 2 or 3 patent lawyers on it at the same time. It always sat in bank. Before the CAFC was created, there were some suggestions that maybe for a while it might have 5-judge panels, especially in important patent cases. It seems to be a vanishing practice. Although the CAFC has the unique authorization to fix the size of its own panels, a 5-judge panel is manpower expensive and decreases the amount of work the court can do. All other circuits sit in 3s. I expect we will. That's Judge Rich from '86. Why did the CCPA sit in 5-judge panels? There was a statutory requirement on the CCPA that no decision could issue without 3 judges concurring in the result. So for 3 judges to concur in the result, sitting in bank allowed the decision to issue even if the panel did not agree. Court of Claims had a similar history. They did not have that same requirement. And originally, the Court of Claims, from 1855 until 1966, 1855 they were created, always sat in bank for the same reason. They also had to have 3 judges concur in order to issue a decision. And so they sat in bank so that they could issue a decision even if there was a dissent. In 1966, that was changed, and they were allowed to have 2 judges to issue a decision. Despite the long and storied history, the practice of sitting expanded panel has become increasingly uncommon. Such panels were much more frequent historically, and originally the Federal Circuit even had an internal rule, which they, from 89 until, not originally, but from 89 until 97, the Federal Circuit had an internal rule requiring 5-judge panels for appeals from the Court of International Trade, where the Court of International Trade had sat as a 3-judge panel. That rule was eliminated, and we've seen very few in-bank cases recently. There are a couple exceptions. In 2007, the Federal Circuit sat as a 7-judge panel. It was 2 appeals combined, and they had each of the 3-judge panels, and then they had the odd man out in order to be meeting with the fight of the statute. And then in 2009, they sat as a 5-judge panel. No explanation given. It was a patent case, so it does align with Judge Rich's idea that you would do this for some of the more sensitive and important patent cases. It was not a more sensitive or important patent case. Panel selection. The Federal Circuit is required by statute to rotate its judges from panel to panel to ensure that all judges sit on a representative cross-section of the cases. They assign judges randomly. This is the same practice that's done in other courts who don't have this mandate. This random assignment, they argue, makes sure that they sit in a variety of cases. If we look at it only as the big breakdown that I gave you originally, where we talk about intellectual property cases, administrative law cases, and money damages, it does. If we look at some of the more fascinating aspects, as Lee pointed out, like the vaccine cases, they only had oral adjudication of 9 vaccine cases in 2010. So to say that that random assignment makes sure they each sit, I don't know. But they do have an unusual practice, which is every judge on the court reads every precedential opinion before it's issued. So I would argue that that actually, in fact, helps with the idea that the judges are assigned to this random cross-section. Why do they do this? Court of Claims, and as Judge Rich pointed out on the CCPA, had specialized judges. So they would have 2 judges who did nothing but patent cases. And there was a concern that the Federal Circuit would evolve to the same concept. And so these specialized judges on the Court of Claims and the CCPAs were the ones that always took the patent cases. And they didn't want this to happen on the Federal Circuit. Federal Circuit's required to sit in such a place so as to secure reasonable opportunity for citizens to appear before the court with as little inconvenience and expense to citizens as practical. What does this mean? In the early days, it meant they traveled a whole lot, 3, 4, 5 times a year. More recent times, it's been slowing down to once or twice a year. The idea is that they give the citizens a chance to not have to travel as far to bring their suits. Could they travel more? Obviously, the Court of Federal Claims is subject to the same mandate, and the Court of Federal Claims does a variety of things. For instance, the majority of their trials are not held in Washington, D.C. The majority of the Court of Federal Claims trials are held all over the country, allowing for this lower expense. On to some of the fun aspects of this. So there are two statutes that I ran into in the Federal Circuit that don't seem to make a whole lot of sense. I probably shouldn't say that. I should come up with some better pedagogical word. But criminal sanctions. Whoever, being a member of Congress who appears in the Federal Circuit, can spend up to a year in jail. They can be criminally sanctioned. Punishment is to be imprisoned for not more than 1 year or to be fined. If you willfully engage this, you can be imprisoned for not more than 5 years for essentially for practicing in the Court of Federal Claims or the Court of Appeals for the Federal Circuit. Where did this come from and why do we have this? Okay. You can be subject to criminal sanctions for appearing in a case involving the U.S. government. Fine. No problem. U.S. Congressman, you shouldn't be in a case involving the U.S. government. I'm good. That's a separate statute. Court of Federal Claims. You're not going to get a case in the Court of Federal Claims that does not involve the U.S. government. Fine. Belt and suspenders. So we have the rule that says you can't represent the government. We have the rule that says you can't be in the Court of Federal Claims. Then the Federal Circuit. Honestly, I think it's a legislative oversight, a drafting error when the Federal Circuit and the Court of Federal Claims came out of the Court of Claims. I think they didn't think about the 30% of patent infringement cases in which the U.S. government is not a party. It's an interesting area. There's also an exception to appearing in a case involving the U.S. government if you are representing a spouse, a child, a fiduciary duty. So there is an exception for representing a spouse in a charge of trespass on real property. There's no exception for representing your spouse in a charge of trespass on intellectual property. Don't know why. And the final little quirk that I'm going to get into is the Federal Circuit has the power to remove judges from the U.S. Court of Federal Claims during the term for which they are appointed. They can essentially impeach the court from which they hear all the appeals. Okay? They've never done this. But, it's not impeachment because the Court of Federal Claims is a legislative court. And as a legislative court, an Article I court, they are not, it's not an impeachment process. They're not subject to the same concept. But it's the only court. I've looked at, for instance, the tax court, which is also an Article I court, the same sort of concept. The only person that can impeach a judge on the tax court is the president. All right? So you have the court from which that hears all of the appeals has the power to remove a judge for misconduct. And yes, misconduct is defined. It doesn't mean they took the wrong parking space. All right? But they have this ability, and it's defined in the judicial code. They have the ability. So I was trying to figure out why the Federal Circuit has this power. And by the way, this is not something that people at the Federal Circuit are thinking about. The Court of Federal Claims, I talked to Chief Judge Lawrence Smith, who is the former Chief Judge of the Court of Federal Claims, and he informed me that every judge on the Court of Federal Claims is aware of this power that the Federal Circuit has. I then talked to, the president of the Federal Circuit Bar Association, and he said, they have what? So, why do they have this? We have to, again, go back to the Court of Claims. And the Court of Claims, which is one of the predecessors, had judges and trial commissioners. And the trial commissioners, and by the way, Benjamin Harrison, 23rd President of the United States, was one of the trial commissioners. Daddy pulled some strings and got him a job a year out of law school. A year after the bar, sorry. We are going back in time, and he became a commissioner. And so the trial division of the Court of Claims was these trial commissioners. And the trial commissioners were employees of the judges of the Court of Claims. And they were so protective of this power that there was some legislation up to change the name of the trial commissioners to judges. But in order for the name change to be judges for the trial commissioners, the Court of Claims would have to give up their appointment powers. And the Court of Claims said, yeah, you guys can live with the name trial commissioner. We want to keep that appointed power. And as part of the appointed power, they also had the power of removal. So when we went from the Court of Claims from your trial commissioners who represented the trial aspects, and the judges who were the appeals process, the judges went on to the Federal Circuit, and the trial commissioners went to the Court of Federal Claims. And so the power was brought with them to remove the judges from the Court of Federal Claims to the Federal Circuit. Again, not been practiced. I'm not sure what would actually happen, but it's really a lot of fun to have a chance to dig into what makes the structure different. It's often referred to as an experiment, but the Federal Circuit has absolutely flourished as we look at this, and as we spend a day exploring some of the different aspects. Okay, it's born again from the ashes of its predecessors. It was referred to by Judge Markey as the Phoenix Court. It's been growing in significance, stature, and strength. But as it grows, we have to realize it remains rooted in this history and brings with it so much from these Court of Claims and the CCPA, and so much of the roots and backgrounds. Quirky it may be, but the Federal Circuit is special for many different reasons, and not the least of which is the judges who populate the court. Thank you.
Great, thanks so much. So we have some time for a few questions. I could just question them the whole time, but if you also have questions, please raise your hand. We do not have a roving microphone. And so if you have a question, speak up a little bit as you ask. Let's start with Greg Vetter.
Start a remark for Beth and a question for Lee and Lisa. Beth, maybe we need the Baldwin rule to keep the Federal Circuit judges in D.C. so the Court of Claims judges have them close so they won't impeach him. If they move to Texas, they're going to be more likely to impeach the Court of Claims judges. So, seriously, for me and Lisa, when I think about the Federal Circuit, I think about the velocity. You know, I say to myself, they get so many more issues on really important things like obviousness more frequently. And you see this when the Federal Circuit wrote sort of opinions addressing the KSR issue when it was before the Supreme Court. So this notion of velocity, maybe I'm wrong, maybe that's sort of the same in other circuits. I'm interested in your remarks on that, Lee, with this empirical work. And then Lisa, this velocity, the fact that they see important issues so frequently, doesn't that influence this responsiveness now?
I mean, I certainly think it does, and I think it's one of the other things we should be keeping in mind. Again, one of the questions I'm asking about is the pace of judicial change and the opportunity, or lack thereof, for things to kind of sink in and percolate. On the other hand, you know, we're dealing with real parties, real lives here, you know, real businesses, and they need answers to their questions. And so I think we have to have a very responsive court in that sense. It needs to be able to, okay, you know, and that's something obviously that we all know is very fun to explain to our clients. When they can litigate a case all the way up to the Supreme Court or on the way to the Supreme Court and have all of the law pertaining to that case suddenly change and affect and apply from that day forward, you know. So I think you need to have a court that's responsive in that sense, certainly. But it's very challenging times when the law is changing as fast as it is, including for the patent office.
What I thought I heard the question there for me was, and so the answer to the question that I thought I heard, which is sort of this question about velocity and maybe how comparable that is to what we see in the regional circuits, is, so here's the answer. I don't know. Right, so, but I'll talk about it anyway. So one of the last slides I showed you, I didn't really break it out very much, where I showed you the sort of Federal Circuit and patent cases. That slide actually compared the Federal Circuit and patent cases against all of the reported opinions from the regional circuits. And then the side on the column on the right was actually against all civil reported opinions. And so, so the Federal Circuit kind of comes in about the same place, like in both in that situation. And so I think the answer to your question, besides being I don't know, is that it probably varies. Right? I would imagine there might be some circuits that because of where they sit, actually have something that might approximate, the sort of the velocity of issues that the Federal Circuit hears, or maybe on a couple of different topics. And then the other, maybe this was the premise of your question, like sort of the importance of the issues that the Federal Circuit deals with. I mean, some of them I think are important. And the only thing I would say is sometimes I wonder if we think that we think they're important because of our, we're like a little myopic about it relative to all the other things that are happening in some of the other cases that, big corporate cases or something like that maybe the Second Circuit gets or something like that.
This is a question. I have a question that was sparked by Lee's, Professor Featherbridge's remarks, but probably all three of you have experience with this. When I was in practice in Chicago, when I was drafting my first brief to the Federal Circuit, I was told by a partner I was working with to only cite Federal Circuit cases. And this was before, This was before the Supreme Court took a kind of resurgent viewpoint, and certainly I shouldn't cite academic articles. I think about a year and a half ago, I did a short study where I looked at about 100 recent opening briefs to the Federal Circuit, and found something like 1% of them, that is one of the 100, cited to any academic article. Maybe this relates to the story I told at the opening of predicting the weather based on how much wood folks are collecting. But I wonder, and Lee, it looks like you may be looking at that, but I just wonder how much you guys think that affects the Federal Circuit's decisions here in terms of what they're being told from the parties, or do they really have a more expansive view where they take what the parties give them, but when deciding they take a much broader view.
So, all right. So I did show bar behavior, right? Sort of at the end, and so we started this. We actually tried to look at briefs and as reported opinions. It's just that the data set for briefs it was a little bit more variable because of the way in which briefs were getting put into the system. But what we found, generally speaking, so this is caveated to the hilt of it being skewed, was that the citation to law review articles in briefs was roughly like what you were seeing in opinions. Not that they were correlating, not if it showed up in the brief would be in the opinion, but that's legal scholars, legal practitioners were doing it at about the same level as the Federal Circuit judges, right? So that's just an sort of general observation. As far as what you should cite in Federal Circuit opinion, just speaking for myself, I was never sort of discouraged to not consider any of the cases or anything that was ever put in the brief. So I don't know, that's just
maybe I got that advice.
Folklore or maybe it's good advice and I just don't know it.
One of the things that I was looking, one of the various documents that I looked at was a discussion, again, in 2002 panel with the and the judges talked about how they prepared for oral arguments. And it was very interesting that each of the judges had a very different approach. Judge Lynn says if it's a patent case, he starts with the patent, and he reads the entire patent before he does anything else. Other judges said they started with the lower court opinion. The first thing they did was look at the opinion. One judge did say he started with the briefs, but he was more, this is definitely not the majority view. So in terms of what you're citing versus not citing, I think some of that will come into play as well.
Professor Lilly?
So this is for Lee. I'm wondering a little bit about whether two questions. One is whether the differing nature of the jurisdiction of the courts explains some of your findings. One might expect, for example, that you're going to see more citations to academic work within the Federal Circuit in patent cases than in vaccine cases. And similarly, in the regional circuits, where you're going to have a whole bunch of cases in which there's both more developed circuit precedent and in which there's probably less academic work. And so a more apples-to-apples comparison might be sort of patent academic citations in these circuits per case compared to copyright and trademark academic citations per case in the regional circuits, right? Something of similar kind of knowledge and complexity. And I guess I also wonder whether there's a way to sort of bring the treatise issue back in, because my sense is that there's actually relatively little citation in the Federal Circuit of treatises either, compared to other circuits which I think are more likely to rely on them. And if there's a way to measure that, that would actually be desirable.
I'll start with the second one, which was so there is a way to bring it back in. It would have to be coded. And in fact, Craig coded those things, and so the data that Craig has actually includes that kind of information. So we didn't collect it, but we could go back and get it, right? So it would just be something somebody has to do. So that's that. And then with respect to doing the comparison. Obviously, Craig's comparison was the one you just suggested, right? That maybe, maybe intuitively, right? It makes sense to compare patent cases to copyright and trademark cases. But then the question would be why? Is it because they're intellectual property cases, or is it because they maybe come from kind of the same kinds of theoretical justifications or normative justifications about this copyrights are producing public goods that are maybe underproduced, we're trying to optimize that. So the answer is it's tough to know. Exactly how to make the comparison, and obviously we went with the sort of across the board comparison, and then tried to start divvying up in different ways. It would be interesting to see, given that Craig just looked at the Second and Ninth Circuits, to maybe look at citations to scholarship in like copyright and trademark across the rest of the circuits, just to sort of see what that looks like. So it is an interesting. You raised an interesting issue, and one that I'm not sure that we've really settled on, like what the right answer to is, like what are the right things to compare, and so of course we're providing one form of comparison.
Paul.
Hi, I have a question for Elizabeth. In most regions of the world, you have 3 levels of jurisdiction. You have a first instance, then you have an appeal court, and then you have a Supreme Court on the top, which deals with a point of general public importance. If I look at the weary way that Bilski found its way to the Supreme Court, it started off with an examiner as first instance. Then it goes to the Board of Appeal and Interferences in the Patent Office, which is the second instance. Then it goes to Federal Circuit, which is a third instance. Then you've got a Federal Circuit on banc, which is a putative fourth instance. And then it goes to the Supreme Court, which is a fifth instance. So haven't you got too many? And wouldn't an immediate solution be for the Federal Circuit to have a rule of practice that on appeal to the Patent Office, it does not sit on banc? And if there's going to be further appeal, it ought to go to the Supreme Court.
So why would you default to not sitting on banc, as opposed to sitting on banc?
Just because you've got too many levels, because
But I'm saying if you want to eliminate a level, why not eliminate the panel as opposed to
that would be equally acceptable, but only sit once.
Okay. The interesting thing here is if you said, for instance, that they were only to sit in bank, you run into a manpower issue, which is a classic argument that was made. As opposed to, it would be interesting to look at it that. There are other situations in which they have, in fact, skipped a level. Vaccine cases are decided by special masters. The special masters then, the case is appealed from the special masters to the Court of Federal Claims. The Court of Federal Claims is then appealed to the Federal Circuit. The Federal Circuit has said in case law that they do not look at the Court of Federal Claims decision. They go back to the special master's decision, essentially rendering null and void the Court of Federal Claims decision as anything other than perhaps advisory. It causes some controversy. So there has in fact been precedent for removing a level. And so maybe they should, if we were to follow that, they would skip the BPAI, which I understand we don't want them to be skipping the BPAI like that.
And of course, right, the Bilski case did skip a level.
It did.
And then it could have gone to the district court before going to the Court of Appeals. So it could have been six levels.
And it might make sense if you do that to say we're going to ignore the BPAI decision. If you come to us from the district court, it might make a lot of sense, honestly, too.
Just as a clarification, in would obviously be sensible for the Federal Circuit to either sit in banc or sit in a panel, but not both.
Right. And I was, and that's something that you could look at.
So, go ahead.
I just want to, so that's an interesting point that you raised. And not to challenge it too much, but one of the reasons we think we have the Federal Circuit, right, is to actually help guide patent policy to some extent, right? And so to the extent that maybe they're supposed to be doing that, maybe when these issues come through, you have the panel take a cut at it, everybody's happy with it, it goes away, we kind of keep the manpower down. But if we have an issue that turns out to maybe be substantial, something that needs to be, a larger issue in the patent law, maybe having the second cut at it by the en banc court, maybe that's still a good idea, notwithstanding you're obviously legitimate concerns about sort of the number of levels we're going through. Because if you're going to try to make some broad announcement about maybe patent policy through an en banc opinion, or through an opinion, maybe you want to get all the judges into it. Just be another rationale for having an extra level. Again, not disputing the obvious concerns about the loss of kids at it.
At this point, we're going to take a break. We're going to take a 10-minute break, and we're going to start. We're going to have Undersecretary Kaplan's keynote address start at 10:20 back in this very room. Thank you so much.